Hello everyone, I'm Jahanvi Pathak and I am an intern at ubAdvocates under Sir Jeevan Prakash, who is an advocate on record in the Supreme Court of India. I'm here today to discuss the topic RTI and judicial independence. Recently, the office of CJI was brought within the purview of the RTI Act, which became a major concern that this may impinge on the independence of judiciary. Now, the independence of judiciary is considered to be a sine qua non in a democracy, meaning that it is an integral or essential part of the democracy. To ensure that the judiciary remained independent, Article 217, Subpart 1 of the Constitution of India guarantees a fixed tenure to the judges of High Court. Similarly, the judges of Supreme Court of India also enjoy a fixed tenure by holding the office up to the age of 65 under Article 124, Subpart 2. Moreover, the judges of High Court and the Supreme Court may be removed from office only by the way of impeachment, which requires a special majority in both the houses of Parliament. It is stipulated under Article 125 of the Constitution that the Parliament has power to determine the privileges, allowances, and rights of judges. This power, however, cannot be exercised to the disadvantage of the one who has already been appointed. Even the oath of office administered to the judges in Supreme Court in Schedule 3 of the Constitution emphasizes on the virtue of judicial independence by words without fear or favor, affection, or ill will. Contrary to popular belief, the higher judiciary is no stranger to allegations of corruption and misconduct among its ranks. These allegations range from embezzlement, judgments favoring one's sons, the disproportionate accumulation of assets, to the infamous sexual harassment allegations against a sitting CJI. However, the various safeguards instituted by the Constitution to keep the judiciary independent and free from outside influence also insulate it from any accountability. A robust information regime under the RTI Act would alleviate the concerns raised by the overall transparency and accountability of the judiciary. The RTI Act, in its preamble itself, declared its objective as to promote transparency and accountability in the working of every public authority. The Supreme Court has conclusively recognized the right to information as an inseparable part of the fundamental right of freedom and expression. It has also played a proactive role in extending this right to various institutions of democratic participation. In the recent case of Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agarwal, the court has taken the much needed step of bringing the office of the CJI under the RTI Act. To do so, the Supreme Court has relied extensively on the judgment in the first judge's case. Although this judgment was subsequently overturned, the court's observation with regard to the disclosure of communications and its effect on the candor of the process was upheld in the RTI case. It was observed that it is in the spirit of freedom of speech and expression that views expressed by the judges be debated and even criticized. Particularly, it was such views were bona fide. Moreover, if there was impropriety in a judge's behavior, it should face public censor, as transparency is a quality that must not be limited to the executive. It was also noted that the sanctity according to the secrecy of the process of appointment and transfer was misplaced and should be discarded with, as and when relevant to the judicial proceedings. Following Justice Bhagwati's approach, the court ruled that there could be no class immunity to the information slot. The court also analyzed the provisions of the RTI Act, ruling that the Supreme Court and High Court, having been established by Article 124(1) and 214 of the Constitution, are public authorities under Section 2H of the Act. The office of CJI is no distinct from Supreme Court itself. The office of Chief Justices of their respective high courts, therefore, are all public authorities. Further, the information is held by the office of CJI in its official capacity and not in a fiduciary capacity, thus falling within the ambit of Section 2J. Lastly, with regard to the exception under Clause J of Section 8(1) of the Act, the information officer would have to balance the opposing interests in privacy and public interest. But information could not be denied solely on grounds of violation of privacy or confidentiality. This has been placed the CJI under an obligation to produce information regarding the appointment of judges to the Supreme Court as well as the High Courts, as well as declaration of assets made by the CJI, provided it has some bearing on public interest and not entirely personal information. The expansion of right to information in relation to the CJI's office has been met with concerns about independence of judicial proceedings. This judicial independence has developed through constitutional provisions and judicial developments. However, as noted, this independence leaves a gap in judicial accountability and transparency. These gaps are characterized by opaque appointment procedures, arbitrary transfers, and a lack of diversity and unaddressed judicial corruption. These have a direct bearing on the independence of judiciary. It is proposed that the application of RTI Act can fulfill these gaps while preserving and enhancing the judicial independence.